and welcome to the Priggya Arora show, where we speak about aspects of law, innovation, and entrepreneurship with people who have been there and done that. I am Priggya Arora, founder of PA Legal, an intellectual property law firm in India, and we have a very interesting guest, partner and patent attorney at Davidson and Capel, and his name is Mr. Clint Mehall. Welcome, Clint, on the show.
Hi, thanks. Thanks a lot for having me. I appreciate it, Priggya.
Thank you, Clint. And I am really inspired by your write-up, your blog. I'll also tag that in the description below. But so that the audience know you better, can you start with your life story and how did you become the person you are today?
So, I got into patent law basically because I think I had, a unique intersection of legal and, analytical abilities. I wasn't essentially like an engineering rock star, and I don't know if I would have been a lawyer rock star, but I think the combination of the two suits me well. So I grew up with a mom that was a reading teacher. So because of that, I think I was directed away from reading and I was more into math and science. So in high school, I took a ton of math and science classes. I did really well on college entrance exam in math and science. So I, naturally decided engineering was a good fit. I got to engineering school, wasn't especially interested in it, didn't dislike it, enough to change majors by any means. But I was a biological engineering major, and generally, if you're a biological engineering major, you need to go to further school. So, instead of just having a bachelor's degree and getting a job, you usually had a master's degree or a PhD. And I figured if I was going to have to go to more school, I didn't want to go to more engineering school. I was either going to go to med school, business school, law school. And one day I was actually out playing frisbee golf with a friend. I don't know if you know what frisbee golf is. It's you throw frisbees into these big cages, and that's essentially the hole. And he was a mechanical engineering major and started talking about how he was taking the LSATs and going to law school for patent law. I was like, patent law, that sounds kind of interesting. When I was a kid in elementary school, we had a program called Invent America that was in collaboration with the USPTO. So, I had a little background knowledge of, invention and the patent process. And I didn't, think about ever the fact that, there's someone that is involved, in the legal side that, writes the patent documents and litigates the patent documents. So then I took the LSATs, did well enough, started looking law schools, ended up in Chicago at DePaul University because they had a pretty good patent law program. And then met my wife there, who was a fashion designer. And because there's no fashion design jobs in Chicago, she moved to New York. I followed her, got the first job that I could, because essentially I didn't know anyone in New York at the time. I knew a handful of people, kind of did some networking and ended up at a firm, and just ever since enjoy doing patent prosecution and enjoy the people I work with.
Wow. So, Clint, I think it's about the environment in which we grow up, and the people we meet shape our lives and our life decisions.
Definitely. Yeah. You hear a lot of people who start off at bigger law firms that have bosses that are difficult or don't respect work-life balance, or just treat them as a means to make money. And I'm thankful that I've had better experiences than that.
Wow, I think you have addressed the problem of law firms very well. More than half of the law firms, I think the environment is such that people start hating the work environment. And it's glad to know that you were not in that environment.
Yeah, there's definitely good environments out there. And I think
Yes.
patent attorneys are generally easier to work with, and there's less drama than other areas of the law. But I agree that's correct. I'm in a networking group, and talk to other lawyers, and the personalities and drama that some of them have to deal with, are not nearly as prevalent in patent law. I think everyone's a little more analytical and level-headed about things.
Absolutely. And I think to whatever extent our science degree also helps, because then we start applying our mind in a very different sense than normal, like in family law and other things.
Definitely. Our brains are trained to work a little differently.
Correct. So, Clint, we'll come to our topic of today's discussion, which is around patent prosecution and effective strategies and analytics that we can use in this area. So, let's start with basics first. Let's give an overview what is patent prosecution and how it works, and then probably we can build upon it.
Yes, so patent prosecution, I guess patent prosecution and patent drafting are usually referred to under one umbrella as patent prosecution. Some people consider patent prosecution, what you do after the patent application is drafted and filed, but it kind of covers, patent prosecution kind of covers both. So, essentially what patent prosecution attorneys do is we get invention disclosures if we're working with bigger companies. If we're working with smaller inventors, we're just getting, detailed write-ups or, details during discussions with inventors. And we prepare, a first draft, go back and forth with the inventor. A lot of times, it's really helpful to, start drafting the claims of a patent application. So as there's the detailed description, which discusses everything in detail, and then there's the claims, which are the scope of protection of the patent application. And the claims, are essentially the most important part. You need a very good detailed description to support good claims, but a lot of times, if you start off by drafting the claims and then you speak with the inventor and you discuss, is this the scope of protection that we want? Could we have a broader scope of protection? Should it be a little more narrow because it reads on something that someone else did before? That's essentially the most important part of the process. And then after that, you file it with the patent office. And, a lot of people that aren't familiar with patent law think that, you file a patent application and then you get a patent and then you can sue people for patent infringement and you're going to be a billionaire. Well, obviously it doesn't, it's a little messier than that. Once you file a patent application, there's a waiting period before you get an answer from the patent office. And that answer is almost always a rejection that your invention isn't patentable. And patent office will cite, prior documents, referred to as prior art that disclose, something similar or exactly the same. And you either have to change what's written in the claims or argue with the patent office. And sometimes, particularly in the US, sometimes this can go on for round and round, and you end up having to appeal to the Board of Appeals within the patent office. And, it's it can be an intense process at times.
Yeah. So, Clint, you very rightly said that sometimes people consider that patent drafting and patent prosecution is one field, and there are attorneys who think that drafting is separate and prosecution is separate. But in any of these cases, I think a well drafted patent application plays a very big role, because in prosecution, we can change the application to some extent only. Major changes in the patent application are not allowed. So, what, according to you, a well drafted patent application forms a place in the effective patent prosecution strategy?
So one of the things that I kind of learned early on in the process, almost through trial and error, I drafted some patent applications and filed them, and they get rejected. And we're limited by language. You're trying to describe something tangible in words, and a lot of times you don't choose, like, you want to describe things broadly, so you describe things broadly, and then the patent office will cite something else that kind of broadly describes what you're describing broadly. And then you want essentially either more details or another way to describe the exact same thing, even in broader language. Every term, can have two different meanings, or the breadth of that term is not always clear. So one, you almost want to describe everything twice. Like a lot of times when I'm drafting patent applications, I use in other words, to kind of go back and describe something a little better, because if the examiner is interpreting the language that way, you can add further details, or not even further details, but different details, with respect to the, in other words, language. And then if you need to, you can get down, to the more detailed level. So I guess the most important part is describing everything with varying levels of detail and varying language. So, so you have fallback positions to go on when you're prosecuting patent applications.
I think that is very good, because if we explain something in two times in a patent draft, the chances of missing an element would be very, very less. And which is important, because at the end of the day, if we do not have support while amending claims, that would be a problem to us.
Yeah, yep, definitely.
So it's
It can be
kind
very
of a double
frustrating.
check.
Yeah, it can be very frustrating at times, because the invention is different, but you don't have the exact language of why it's different. And you point to the patent application and you say, oh, if I would have just said, one more sentence here or two more sentences here, it would have, saved the client, rounds and rounds of arguing.
Yeah. I understand it. Why? Because sometimes, clients change their attorney, and in the prosecution state will get a patent draft, and exact copy of claim is written in the description. Nothing else is written. And then we feel like, oh my God, now how to explain the examiner that this stuff actually means this?
Yeah, yeah, no doubt. Thankfully, in the US, particularly with mechanical inventions, you can kind of stray from the exact language of the claims or the specification to a degree. But if you're in other jurisdictions, for example, Japan and Europe, you have to have the exact language in the detailed description. So it can be very frustrating.
Yeah.
Actually helped, at the beginning of my career, would send instructions to attorneys in Europe, in Japan, to add language, that we'd added in the claims to the US, and they would respond back that, oh, no, you can't do that. And I, being an arrogant young attorney, I was like, well, just give it a shot. This is what we did. We wanted to do it. And, they were always right. So
I know. Europe is a bit stricter jurisdiction in terms of the requirement that exact language has to be there in the patent specification.
yeah. And I had to learn that the hard way. So hopefully if anyone watching can, even get a nugget of knowledge out of this, it's to draft your patent applications from different jurisdictions.
Yes, absolutely. And Clint, also, like, once the drafting is complete and we enter into a patent prosecution stage, so I say it's a negotiation between a patent attorney and the examiner, mostly, because then we start having written conversations, then sometimes the oral conversations as well. And
Yeah.
you prefer doing PTAB analysis and framing arguments based on that. So, can you tell us? Because I think very few attorneys use this practice. So, can you tell us something more about it? How do you use that studies?
Yeah. So even when I started practicing, it's very difficult at first to determine whether the examiner's wrong, because they'll cite portions of, in the US, they cite portions of the MPEP, and it seems to be correct. And, as a young attorney, you don't know. You can ask, obviously, the attorneys you're working with above you, but, part of developing yourself professionally is trying to figure stuff out on your own. You don't want to go bothering your supervising attorney on every single little question about things. So I started, I guess, researching on the internet, and in the past about, how you could respond to these arguments. And there was always, a few blogs out there that you could find pretty good content on, that would go through, some appeal decisions from within the patent office, it was before the PTAB. The PTAB, came in 2011. So before that, it was the Board of Patent Appeals and Interference, which didn't really change anything from the prosecution aspect of appeals, but it had a different name. So these Board of Appeals, decisions would come down either saying, affirming the examiner, saying that the rejection was correct, that that the portions that the examiner cited in the MPEP were correct, that the examiner was combining references in an obviousness rejection in the correct way, or the examiner was wrong because of, the examiner, didn't consider this area of case law, or didn't consider, this portion of the MPEP. It was usually case law, the Board of Appeals. So I read a ton of blogs, read a ton of decisions just to get a good handle on when I was right and when I was wrong, and be able to frame arguments in that way. And a couple of years ago, I got a subscription to Patent Advisor from LexisNexis, and they have a great feature in there called file wrapper search, where you can search essentially for any document that's the file wrapper, is the record within the patent office of a patent being prosecuted. So it's everything from responding to the rejections, to the rejections themselves, to the appeal brief that you file, and then the examiner's answer in response to the appeal brief, and then the board decision. So you can narrow by document type, such as board decision or appeal brief, and you can create these briefcases and then get numbers based on the briefcase. So, to kind of take a deeper dive into whether the arguments that I was potentially using would be successful, I would create, I would do file wrapper searches and limit it to the board decisions, and then I would use specific language of our common arguments that I had used. And when you create these briefcases, you can see the analytics on them. You could see, what percentage of the appeals were reversed, what percentage of the appeals were affirmed. So it kind of gives you, a reasonable correlation about whether an argument is usually successful. So, everything's fact specific. So an argument that didn't work here might work here, or possibly the attorney just didn't make the argument as well as you could have. So, it's not the end all be all. And also, a lot of times board decisions will mention a bunch of different arguments. So, it's not necessarily a one-to-one correlation, but I found that by running these analytics that you could see, at least based on probability, which arguments are more effective and less effective. So if you have an argument that could kind of be phrased two different ways, you can look at the analytics on it and say, this argument is not working generally at the board. This argument is working more. I'm going to go with this argument instead. Or if I'm going to make this argument, it's not going to be the first argument I make. It's going to be the fifth argument I make. Like it's the long shot. Doesn't hurt to try it at the end, but you don't want to try to rely on arguments that have a low probability if you don't have to.
Clint, what is your favorite argument?
My favorite argument?
A non-obviousness objection comes or a novelty objection comes. In these two cases, what will be your favorite argument?
I would say I like to argue that there's no factual basis for the examiner's rejection, that it's speculative. So I can pull up the exact language, but there's a case that I rely on a lot. It's called In re Warner, and it says rejections must rest on a factual basis. They can't be based on speculation, conjecture, or hindsight interpretation. So a lot of times, the examiner is trying to say this reference discloses this, when the reference, the examiner is reading more into the reference than is actually stated in the reference.
Yes.
So the examiner is speculating. So that's something I try to use the term speculative as much as possible when I'm filing appeal briefs. And if based, and I've been doing this for years, using that argument. And I came across, these analytics and ran it through a couple of years ago, and it's like 85% reversal. If you can get the board to use this quote about no factual basis and speculative, you got a pretty good chance of winning. You can you can include it in your appeal brief, and the board might not address it, but if you can at least make the argument convincingly enough to make the board address it, you have a pretty good chance of winning.
Wow, I'm now you just shared your trade secrets, and we all are going to use this argument a lot.
Oh, good. Yeah.
Wow.
Happy to help anyone else win appeals against bad rejections.
That's so kind of you. So, Clint, now we'll come to language, because I think that also plays a very, very important role while drafting the responses or the application. And we touched upon it when we spoke about patent drafting. But what do you think the frame of language and the effect of it on the acceptance of patents?
So language is very tricky because we use a lot of terms kind of loosely in conversation.
Yes.
And if you look up the definition in the dictionary, it doesn't always mean, as specific of a term as you intend, or it can be a broader term than you intend. So particularly early in my career, when I was drafting patent applications, you'd get a rejection from the examiner because in the US, they follow the broadest reasonable interpretation standards. So every term that's used in a claim, the examiner interprets it as broadly as reasonably possible in light of the application, in light of the detailed description and the drawings. So there would be times where the examiner would say, the claim said this reference reads on this. I would say, I'd think to myself, no, it doesn't. That doesn't make any sense. And then I would look up the dictionary definition to, potentially argue. And the dictionary definition would be a little different than I thought. And I'd be like, yeah, I guess the examiner has kind of a good point about that. So then when I would draft applications after that, I would look up, even, common terms that you think everybody knows the definition of. And it wasn't always as clear as, I thought it was. So that is where, describing something in other words or at varying levels of detail really comes in handy. If you want your definition to mean one thing, you should kind of describe it a little differently or a little better, or sometimes in patent applications you can say, defined herein as, and then you provide the definition. It's not something most people do commonly unless you're in a really technical space, and using real technical language that can mean a couple things. But it's almost surprising at times how much terms can vary in their meaning and how people can interpret different terms differently.
Yeah, I always give this example. A and the is so tricky in the patent application. Like if you miss antecedent basis, you are going to receive an objection to the patent office. So even the word small words like a and the that we use very, very loosely plays such an important role in the patent application.
Yeah. And a lot of times, at least at the beginning of my career, the patent examiners would reject to the term and or.
Yeah.
In your claims, you say,
Correct.
that this can have, this feature and or this feature.
Correct.
And the patent office would reject it as being indefinite, which is insanely illogical. So most people would change it to at least one of,
Yeah.
but then there were some pretty good decisions actually at the Board of Appeals that said, of course everyone knows what and or means. It means, it can be one, it can be this one, or both of them.
Yes.
So, sometimes it's easier just to appease the examiner as opposed to, trying to fight tooth and nail about everything. But if you have a pain in the butt examiner, sometimes it's, helpful just to take a hard line and, your client's not going to put up with, ridiculous interpretations of things. So.
Yeah, maybe that is the reason, because when I started patent drafting, we always use at least one or more instead of and or. We
Yeah.
never use that in the patent claim specifically.
Yep. And most of the time, I still will use that language, but it's also sometimes the language is super clunky if you're using at least one of. So it just makes the claims harder to read. It usually makes the claims harder to read.
Correct.
Most patent attorneys are used to reading it that way, but and or is just a lot cleaner.
Correct. Yes, probably next time if we receive any objection regarding and or, we can show them this decision like, okay, this is acceptable.
Yep. There's a great blog post on Mr. IP Law about and or a board decision and or. So if you want to find the decision, you can check out that website and search through it. It's a really good blog.
Perfect. So Clint, now we'll come to the interview stage, because that is also one of the important stages. So why is interview with the examiner conducive to getting the patent allowed? And do you advise, like, after we receive one or two office actions, we should directly go to the interview, or we should take a chance of having again the written responses?
Yeah, examiner interviews can be really helpful. There's some patent attorneys that say you should interview every single case. I don't really agree with that. I think that it's fact specific, but certainly if you're not getting anywhere with a patent application, it definitely helps to interview with an examiner. And there's certain issues that are helpful to interview on. For example, if you don't understand how examiner is interpreting the claim or a prior art reference, instead of arguing back and forth, like, you're wrong, this doesn't disclose this doesn't disclose this, you don't understand what the claim means. It's much easier to just call the examiner up and say, hey, not really sure how you're interpreting this. If there's a way that we can make some minor amendments to get around your interpretation, that'd be extremely helpful. And examiners are usually, I think when anyone is writing, their tone is a little less friendly or unreasonable at times than if you're speaking to someone. Just the nature of human communication. It's like when people are texting back and forth about something and they should call each other and end up getting a big argument over something needless. I think that's almost comparable to arguing back and forth with an examiner about certain issues. So if you get the examiner on the phone, they realize you're another human being that's not completely unreasonable. You realize usually that they're another human being that's not completely unreasonable. There are some examiners that are completely unreasonable, but it personalizes it. It makes you take a step back and analyze, like, if I was in their shoes, maybe I would have a similar point of view. And also, it just, I think to a degree, it personalizes the case more to an examiner. It's not just something that's filed on paper. This is something that, usually for me, it's, corporate clients. This is something that a corporation, thought was important enough to file a patent application on. It's not something trivial that, this is actually something that's meaningful. So, if the examiner can, give serious consideration to help the applicant, determine, what is patentable, what is not patentable, it can go a long way.
Wow, that's interesting. That I think interviews are good, and Like when I handle hearings in India, we say hearings at the patent office. So when I handle, so sometimes the examiners are very friendly. They will give you suggestions like what we can do. Sometimes they are not, and they
Yeah.
outrightly reject whatever argument you make. So according to you, do you do the examiner analysis before the interviews? Do you know about how they are going to react with the patent application? Are you able to figure it out after an experience of so many years?
Yeah. Oh, I mean, you can definitely tell a lot about an examiner by looking at their analytics. So
Yeah.
uh, Patent Advisor, the tool that I use, and there's a lot of other good tools,
Mm.
patent bots and Juristat, they'll show whether the examiner's allowance rate is higher with an examiner interview compared to without an examiner interview. And sometimes it's like 60% higher with an examiner interview.
Wow.
So these are examiners that, they they might be much better at conveying things verbally,
Yeah.
than they are, in writing. You might not understand their position in writing, or they might, not understand your position as well in writing. So examiner interviews, are totally necessary in those instances. Like a lot of times, if we're trying to figure out, strategy for a patent application, and we're reporting, the rejection to the clients, and we want to put a suggestion in there, we'll look at the examiner analytics and say, if it's 60% higher, we highly recommend, interviewing this case. And then after you have enough experience, in a certain art unit, you start to get to know the examiners too. So I know, certain examiners are just not worth the time arguing back and forth with paper. Let's call them to understand their position, hash it out that way. There's
Yeah.
also some examiners that you're wasting your client's money if you try to call up an interview with the examiner, because there's some examiners that are just kind of arrogant. And if you suggest if you're bouncing strategy off them, saying, well, what if we amended the claim in this way? They're like, well, that's kind of obvious, that they they speculate, again, going back to speculation, which, you're better off just filing an appeal against examiners like that. There's no point in calling them up to hear them speculate.
Yeah, for us, they'll say you give a written response again and we'll review it.
Yeah.
Because
Yeah.
in India, we have to give along with the hearing, whenever any hearing happens, we have to give a written response along with that as well. That what
Yeah.
happened, the hearing and mm,
Yeah.
the drafting documents. So that's so good, Clint. And now we'll come to a rapid fire round, which is about you and your life again. So answer these three questions very quickly. Three things
Sounds
in
good. I'll
wow.
try my best.
Three things in life you're grateful for.
Oh, just three? No. Family is very easy. I have a daughter who's 6, and then twin boys that are 3. They're definitely a handful, but they're a lot of fun. They make, our house a much more enjoyable place. I have a lovely wife that I'm very thankful for. My parents and my wife's parents are very involved with the kids. They live, we live in the New York City area. My parents live in Illinois. My wife's parents live in Ohio, but they come a ton. My in-laws are actually coming today, and they'll stay with us for about 10 days. So extremely, grateful that they, have such a loving relationship with the children. And also my wife and I can take vacation sometimes to get
Wow.
away. So I think that's all. I'll count that as one. Number two, kind of, going back to, why I've been at the same firm my entire career. Just really grateful that I've been around, people that have treated me well. My mentor, name's Bill Garris. He's treated me fantastically my entire career. He's a great guy. He has a great strategy on work-life balance, which I think has, helped me not burn out, he thinks that family is very important, and people that are around people like that generally are happier in their careers. And number three, I guess I'm very grateful that I played that round of frisbee golf with my friend 20 something years ago, and was exposed to patent law, because it's really a cool field to be a lawyer in.
Wow. So interesting. Now, two traits that you think are useful for an innovator.
An innovator, well, one I think is questioning how everything is done. The innovators, we're always trying to think outside the box and look at different ways to do things. I would say that I don't have an innovator's mind. I don't think I can handle the patent applications and patent process. My wife has more of an innovator's mind. She's more questioning stuff around her and always trying to look for a different way to do things. Number two is, I guess, not being afraid to be wrong.
Wow.
Because I think, and that might be my problem too. I'm constrained by, I don't want to have this idea that is ridiculed. And I think if you're an innovator, you have to be able to put yourself out there, say, this is what I thought of, this is what I came up with, because it's kind of a vulnerable position to put yourself in, particularly if you're going to file a patent application, because the patent office comes and can reject you and say, this isn't innovative, you're not innovative. So I would say the ability to question things, and also the lack of fear of rejection.
Wonderful. I think both aspects are so important, curiosity and lack of fear of rejections. And
Yeah.
now, can you share one aspiration you have for the future?
That's a difficult one. I don't
Yeah,
know.
after 20 years in the career, it's a difficult one.
Yeah, I would say, just to continue to grow my practice and work with, some fun clients that are doing really interesting stuff, and to be able to help them, protect their inventions and, strategize the best way possible. And so they don't, look back and think that, oh, I wish I would have done this. I wish I would have done that.
I think that is very, very important. So Clint, any key takeaways that you want to share for our audience?
Probably try to meet and talk to as many people as possible in your field. That's something that I've, over time, and I guess the first 10 plus years of my career, I wasn't that great at, but recently, I've interacted a lot more with patent attorneys, actually on LinkedIn, which is where we got connected.
Yes.
Is just a great atmosphere for getting to know people. I've made a ton of friends. I've met people that I consider friends now, that I just met on LinkedIn, and I've actually learned a lot by interacting with other patent attorneys on LinkedIn, or through Zoom calls, or even meeting in real life after meeting on LinkedIn. So, and then also I'm involved with the New York Intellectual Property Law Association. I co-chair the Patent Law and Practice Committee, and I think that's also been really rewarding, meeting other patent attorneys in that context, and bouncing around ideas, having lunch and just chatting about the little aspects of patent law that I didn't have the ability to discuss earlier in my career, when I wasn't really hanging out with anyone in my field.
Wow, that's good. I think meet as many people as you can, so that you get an opportunity to learn and grow in your field.
Yeah, because I mean, particularly when you're trying to figure out how to be good at your job at first, you're trying to put as much time into actually doing the job, and then when you're done with that, you want to go to your outside life and do stuff with your friends and family, and forget about the job. Well, it's just, I guess, a better, more rewarding strategy to try to spend a little bit of time. It doesn't take too much time, a little bit of time away from work doing these things.
Wonderful. I learned so much from you from this interview, and I'm sure the audience also learned a lot. So, Clint, thank you so much for accepting my invitation and being on the show.
Yeah, thanks a lot for having me. It's been a lot of fun chatting with you.
Thank you.
Yes, you asked very good questions.
Hey there, thank you for attending today's session. If you enjoyed the session, do follow our channel and consider sharing it with a friend. My name is Priggya Arora, daughter of inspiring parents, alumna of IIT Kharagpur, engineer turned lawyer and entrepreneur, and now founder of PA Legal, where we help creators and innovators protect their intellectual property. Thank you.